We'd like to welcome Attorney General David Eby to chat with us for a moment at the ADRBC 2018 Symposium. Welcome, David.
Thanks for having me.
It's great to have you with us. And one of the questions that I had for you is really about what is the role that government has in promoting and making accessible ADR services to the public, you know, whether it's at home, at work, at play. What sort of role is that for government?
We have some really formal structures in British Columbia that incorporate ADR into legal processes. So if you are involved in a dispute around a child protection issue, we support Mediate BC to maintain a roster of mediators that will help resolve those disputes outside of court. That's where we draw the dispute resolution folks from, is from this list of people maintained by Mediate BC. We have a new mechanism by which people can access small claims court type justice or resolve a strata dispute called the Civil Resolution Tribunal. And baked into that process, it's a less adversarial process than a traditional court, is a full dispute resolution process. And we've seen very significant numbers of disputes that don't actually go all the way to a final resolution because they've been resolved before the full hearing process in the Civil Resolution Tribunal. And so that's small claims disputes under $5,000, strata disputes, and recently more minor injuries in relation to car accidents dealing with ICBC. So there are formal processes, like almost court-like processes, where dispute resolution has been baked in from the beginning. And then there's dispute resolution lists that are maintained in partnership. And then where are we going is the big focus right now for our government is Indigenous justice and Indigenous rights. And we're working with the Aboriginal Justice Council of BC to find different ways of using alternative dispute resolution around addressing the fact that we have way too many Indigenous people, way disproportionate number of Indigenous people in our prisons or involved in the child protection system in some way. Right. So we have these family justice centers, these parent legal centers that we're setting up to help parents access dispute resolution mechanisms outside of the full court process. And we also are working on something called GLUDU reports and GLUDU principles, which ensure that the specific circumstances of an Indigenous offender in the justice system are taken into consideration. And that helps the judge. It's within the justice system, but it brings in some alternative dispute resolution principles into that process. So there's lots going on.
Yeah. It's quite busy.
Yeah.
And so then just one more piece that I think I'd love to hear a little bit about is this Indigenous court processes.
Mm-hmm. We have First Nations courts. I've had the privilege of being at a couple openings in Prince George, and I was in Merritt. And it really feels like when these courts open, like the community is, the local First Nations community is taking control again of the justice process that they would have administered, of course, obviously before contact and before colonization, and all those processes were taken away from them. So it feels like a bit of a return, and it's within the existing rules of the provincial court, how these courts run, but it looks very different. Everybody sits around a table. There are two elders that participate as well that come from the local community. And what the elders do is they really bring the community's voice to the table around who is this person that is in contact with the justice system, how can the justice system support this person in rehabilitation, how can the justice system address the community's desire for there to be some denunciation about the kind of thing that went on here. Right. And they help inform defense counsel, Crown Counsel, and the judge, who are all dedicated to this process, about what the best way forward is. So it's really a mix between an ADR process, a restorative justice process, and the more formal provincial court rules.
Yeah. And do we have time for maybe
of course, yeah,
quick?
Sure.
Because part of with that, one of the questions that sort of starts spinning in my mind is how much of that is then informed by what the local First Nation, what their justice system would have looked like and what sort of rules would have been there, and how does that sort of interact with the provincial requirements and regulations there?
That's something that the elders really bring to the table, is they can talk about traditions within the community, they can talk about community expectations and how the community would have dealt with issues like this previously. But I don't want to oversell it in terms of what it is. It's a provincial court process. It's within the provincial court rules. So it's still very much a provincial court process. We're looking at that next step, which is the one you're talking about around traditional Indigenous justice responses as part of restorative justice. And that's the next step. So this first one is, it still looks, parts of it look very much like provincial court judge or provincial court, because there's a provincial court judge and there's a bailiff and there's kind of held on defense and all that. And then the next step for us is the more restorative justice approach that is closely associated with some Indigenous traditions.
Cool. Well, thank you very much for
Thank you so much for
joining us.
taking
Yeah,
some
thanks for
time.
having me.
Thanks.